Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. You're my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are.
It's another wonderful Saturday afternoon with us here in the UK, and we're live on BWTV. This afternoon, I'm going to get you into looking at how we can file an appeal and go through that successfully. Our guest and friend and resource person, lawyer Charles Asma, will be on hand to do that. This afternoon, we have some updates as well for you. So I would entreat you to ask the other person, to tell the other person that we are live on BWTV. My name is Oreku Frimpong, and welcome to the community and the law. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, hello, hello. Another wonderful occasion is here with us. A very hot Saturday afternoon here in London, and we are so delighted to come your way with the sunshine, bringing you something that will help you understand your immigration situations. And when things turn south, what do you do? When decisions do not go your way, what do? You probably would want to go through the steps to the point where you launch an appeal. The critical factors in succeeding in an appeal are the things we're going to look at this afternoon. So I believe that you're so ready and you want to tell other people to come join us on the Community and the Law live on BWTV and also live at BWF Solicitors on all social media platforms whilst we delve into it together. My name is Oreku Frimpong, and I'm delighted and happy to have a friend and brother from the stables of BWF Solicitors, Lawyer Charles Asma, to be a resource person and guest. Lawyer Asma, good afternoon.
Good afternoon, Brakuku.
Thank you so very much for joining us and lending us one of your Saturday afternoons as well. How are you doing? I would want to ask first of all.
Very well. By God's grace, keeping well.
Well,
Ready to
we thank
stand.
God for mercies. Yes, this afternoon, as I mentioned, is a very sunny Saturday afternoon here in the UK. And I believe people are so relaxed. Some probably have gone to the gyms in the morning. Some have gone for swimming and back home and relaxing. And everything is going to be all right because we're going to learn a lot. So those of you who have joined us, we're live at BWF Solicitors on Facebook. We're live at BWF Solicitors on YouTube, and at BWTV, both on Facebook and YouTube. Those who would want to send me your text, your questions concerning what we're going to discuss, or any other thing that is on your mind and you want to put it to Lawyer Charles Asma, you can text it to 07399 208 468. 07399 208 468. When the lines are active, you will be calling on 0208 493 7345. 0208 493 7345. But let me tell you that we are doing this courtesy of BWF Solicitors. So you'll need their numbers as well. BWF Solicitors is available to everybody here in the UK who would want to engage the services of reliable solicitors and lawyers to help them, especially when it comes to immigration matters. You can locate BWF Solicitors on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And you can get to book an appointment, come and see them, or contact them on this number 0208 493 7340. 0208 493 7340. Or for emergency situations and at all times, 077 127 61884. 077 127 61884. So invite others, allow them to have the opportunity you are having so we can do this together. Your questions will come, your answers will come, and definitely I will also be testing you on the nugget I am going to put across. So I have welcomed Lawyer Asma, I have welcomed you. Let's get into it now together. The nugget we have earlier on is coming. It was put out on Monday, but we're going to do that later on. One person thinks that everybody should know how BWF solicitors have helped them. And Osei says, I'd like to express my sincere appreciation to BWF solicitors for their exceptional support throughout the visa application process for my daughter. Their team demonstrated a deep knowledge of immigration procedures and provided clear, timely guidance at every stage. Thanks to their professionalism and dedication, the visa was granted successfully and without complications. I highly recommend BWF solicitors to anyone seeking reliable and effective immigration legal services. So, yes, you know, and I've given you the number. I want to repeat that and reiterate that. Visit BWF solicitors 0208 493 7340. 0208 493 7340. Now, those of you in Ghana, there is an office for BWF solicitors and they are open for consultation and your visit as well. You can call them on 055 589 5959. 055 589 5959 if you're in Ghana. In emergency situations, as I said, there's a UK number. You can text, you can send a WhatsApp message, you can call 077 127 61884. BWF solicitors are trusted partners when it comes to the law. Yes, I mentioned that and I get earlier on, and I said that you look out for it on all social media platforms on a Monday before noon. It will come out and you can follow out. If you have any questions on that, you can either wait so we'll come here on Saturday on Community of the Law, or you can call BWF solicitors and they will have the chance to give you extra explanation of that. Today, what are we looking at? We're looking at those who apply to renew their leave to remain in the UK, who risk delaying their 5 or 10-year continuous resident period to indefinite leave to remain. Whilst paragraph 39E of the immigration rules allows for extension of leave within 14 days of the visa expiring, such delays and any subsequent delays up to the date the renewal decision is made will be deducted from the qualifying period to settlement. This one is from paragraph 39E of the immigration rules on the application of EAK versus Secretary of State for the Home Department. And this is a UK Supreme Court case of 2022. And it's also based on another R on the application of Afzal versus Secretary of State for the Home Department, who was the respondent in 2022, another UK Supreme Court case. Now, this has come up, and I believe that people are getting things kind of confused. Well, I have applied, I did it on time. Within the 14 days that the allowance is around, I did. But why are they deducting all these things from me and telling me probably my number of days are not up to it and the rest of it? Listen, let me go to Lawyer Charles Asma. What are the issues around this one, Lawyer?
Thank you very much, Rangoku. Viewers and listeners, the matter for consideration within the nugget is when I delay in making my application for renewal.
Mm-hmm.
And because of my delay, Home Office also Home Office will always delay because you don't apply today and you get a decision today unless it's a priority application. Even that, sometimes another day. So there's always a delay from the Home Office. But the question of who caused the delay? If the
Okay.
delay, it's not that you caused the delay per se because you were late. So whenever you delay, Home Office will automatically add their delay to your delay. So make sure you don't delay. That's the starting point. What do you mean by we've delayed? We can delay because of money issues. We don't have the money to apply to extend or renew. We can delay because of health. We are unwell and we are not able to instruct a solicitor or do it ourselves. And by the time we got better, we've run out of time. We can also delay because we forgot or we didn't check the expiry date. These are three reasons why delay is possible. And so within the immigration rules, we have amnesty for delay, which rests within paragraph 39E of the immigration rules. There's also full protection without delay within the law under section 3C of the Immigration Act of 1971. Section 3C is full proof. I call it full jacket from head to toe. 3C. Everywhere is covered. Full jacket, 3C. That means insofar as your visa is valid and you give it to the Home Office and it takes forever for them to finish, you are okay. Full proof, full protection. Paragraph 39E is where you are late to apply to renew because sickness, forgetfulness, or funds were the issues. However, your application is being submitted within 14 days of the visa running out. And so because of the fact that you were late, but you still remembered to do it within 14 days, there is half protection.
Okay.
Half protection. So 39E is half protection where you were late, but you did it within 14 days. We are not going to talk about those who did it after 14 days, within 14 days.
Within 40 days. Okay.
So on the 14th day, you did it, or before the 14th day after the visa has expired, you renewed or you applied to resubmit for extension. Right. So that's the starting point. And so what happens to those who did the right thing but not forgetting about their visa expiration date and they did it on time against those who forgot for whatever reason? Should we put the two people on the same scale?
No, because one they applied within different periods, isn't it? So we can't put them on the same scale.
Yeah, otherwise it will appear that if you delay, there's no punishment. If there's no punishment, everybody can delay anyway. Imagine everybody becomes illegal for 14 days. Then we are breaking the rules anyhow.
Yeah. People will take liberties and do things their own way.
Exactly. And therefore, if you delay, there is punishment for it. Even if you delay for 1 day. So what is the punishment? The punishment is that whenever you apply because your visa expired and you remembered to apply to renew it within 14 days, you are late. And therefore, the sanction is that when it is time for your indefinite, you have to make up for the delay.
Okay.
So you have to give yourself extra time before you become due for indefinite.
Okay.
That means where there's no delay, there's no punishment. But where there's delay, there's punishment. The punishment is that instead of getting your indefinite early, you get it later.
Okay.
Because you have to make up for the delay. Now, you have delayed. So ideally would have been 14 days punishment. But because Home Office is also going to delay automatically, they will add the delay there to your delay to make up the total delay. So accumulated delay. So what we are saying is that whenever you delay and you apply to renew within paragraph 39E, which is the amnesty period or the half jacket protection period, you are going to wait for that period you have delayed, plus the period Home Office delayed to respond to you with your decision before your time for indefinite becomes due.
Okay.
So
So if I applied, say, within the period, and Home Office delays for 2 months, for instance, will my indefinite leave to remain delay by the 2 months the Home Office have, or when they give it to me, they will backdate it and make up for the delay they have caused?
well, when they give you the visa, they will give you the visa up to the time they issued it. But when it is time for your indefinite, you know that, okay, my visa, this is my last renewal, and I've been given up to, for example, 1st of January, let's say 2026. So you know that 1st of January 2026, 28 days to that 1st of January 2026, you can apply for indefinite,
Mhm.
because that's your last bit, 10 years.
Yeah.
However, in your case, it's not going to be like that because you delayed. And so when you were going to apply at a point to renew, you didn't do it on time. So there is a backlog of delay or arrears of delay to make up for. Plus the Home Office delay. Let's say you say Home Office delayed for 2 months and you delayed for 10 days. So instead of within 14 days, you apply within 10 days, making 2 months and 10 days, isn't it? Accumulated delay.
Yes.
So Home Office, if you put in days, it's going to be 2 months will be 60 days, and plus your 10 days, making 70 days. So instead of the visa expiring, instead of you renew going for indefinite from the 1st of January 2026, when your visa, your 10 years is up, you have to wait for another 70 days
Okay.
because you there has been a delay. So you're not going to benefit as those who didn't delay or those who stayed within 3C would benefit. So if you stay within 3C, when your visa is about to expire within the last 28 days, you renew. By this time, you've done your full period of 10 years, for example, or 5 years, for example. So you apply for your indefinite because the law says that after 5 years on this, you apply for indefinite, or after 10 years, you apply for indefinite. And you don't wait for the last day to go. You operate within the last, so that the last 28 days you apply. Because nobody, if you have everything ready, will wait for it to expire again. Because if you expire, then you become an overstayer. You cannot submit your indefinite. So let's keep it simple. So the case of Iyaki, for example, and Afza, one of them was about appeal. They were refused and they had 14 days to appeal. And they didn't appeal within the 14 days. So they asked the court to give them extension of time to appeal. And the court agreed because they were unwell and blah, blah, blah. The court agreed and gave them extension of time. And the matter stayed in court for about 2 years, for example. And then by the time the matter was over and they were issued with their visa, it has stayed with court for 2 years. And also, they also took about some time, let's say 30 days, before this appeal was accepted because they were late to send the appeal. So they delayed in submitting their appeal, and the court also concluded after 2 years, making 2 years and 30 days. So when they submitted the indefinite leave to remain, Home Office said that you were late to apply to submit your appeal. Court also took some time to make a decision, and therefore the accumulated delay of, for example, 2 years, 30 days, you have to wait until you go for your indefinite. So instead of going for indefinite, they had to apply for another 2.5 to make up for the lost time because the visa had then expired. And so when the visa expires and you are due for indefinite and there has been a delay from your side during your renewals, you cannot apply for indefinite. You apply for normal renewal, 2.5 again, to make up for the lost time. Again, the case of Afzal. In this case, the person makes application for a fee waiver. Fee waiver was rejected. The person was given 10 days to pay and submit the application. The person makes another fee waiver application, and this time fee waiver was accepted and put in the application. But remember, that 10 days that was given for it to be under Section 3C was not used. And therefore, by the time the second fee waiver came, they had already been out of leave to remain. Their visa had long expired. But Home Office considered on humanitarian grounds and granted the visa renewal. But when they were due after 10 years for indefinite, they reminded them that, remember, you were late and you submitted another fee waiver when you have no visa at all. We gave it to you, but then that delay from your side and from our side, you have to pay for it. And so you have to make another 2.5 application until you are properly 10 years before you apply for indefinite. And that has become the legal position that when you operate within section paragraph 39E in submitting your application, that delay and the delay from the Home Office, you have to make for time for it. And so when you think you are due for indefinite, you don't have to submit because of that delay. So you have to check the timing, calculate the delay period, and know when you will be due for indefinite.
And based on this, I would definitely advise that if you are putting in an application, it will be best for you to consult a solicitor, a worthy one, of course, like BWF solicitors, who have lawyer Asma, lawyer Eunice, Uncle Ben himself, and all the other persons and the professionals in here, so they can check for you so you don't fall foul of what we are talking about. We have been saying that those who apply to renew their leave to remain in the UK risk delaying their 5 or 10 year continuous resident period to indefinite leave to remain. Whilst paragraph 39E of the immigration rules allows for extension of leave within 14 days of the visa expiry. Such delays and any subsequent delays up to the date the renewal decision is made will be deducted from the qualifying period to settlement. Lawyer Tazasma has explained, and there are two cases, Yeke versus the Secretary of State for Home Department, and also Afzal also versus the Secretary of State for the Home Department. Both 2022 UK Supreme Court cases are cited to do this. And he said something just before he ended. It has become the legal position. So I would again reiterate the advice I gave you. If you are putting in an application, you may want to give it to a lawyer to help you do that. Consult BWF solicitors. Contact them on 0208 493 7340 0208 493 7340. Well, that's by way of a nugget. And with the nugget, I always come up with a scenario and I ask you the question. Now, our dear friend Jane entered the UK as a dependent of a British citizen. She was granted the 2.5-year leave to enter, expiring on the 15th of May 2025. She submitted her renewal application late on the 25th of May 2025 due to lack of funds. On 15th June 2025, she was granted another 2.5 years or 2.5-year visa to remain, which is valid until the 31st of December 2027. My question is, when should Jane apply for indefinite leave to remain? I've got 4 answers for you today. Today I've expanded the scope a bit more. 4 answers. Latest by 3rd of December 2027. Latest by 31st December 2027. Latest by 2nd of January 2028. And latest by 31st of January 2028. Think about it carefully. I'll come back to you at the tail end of the program to ask you what your answers would be. Jane entered the UK as a dependent of a British citizen. She was granted 2.5 leave to remain, leave to enter, which was expiring or expired on the 15th of May 2025. She submitted her renewal application late, which was 10 days later from when it expired due to lack of funds. On the 15th of June 2025, she was granted another 2.5 years, which is valid until the 31st of December 2027. My question is, when should she apply for indefinite leave to remain? Would it be latest by the 3rd of December 2027? Would it be latest by the 31st of December 2027? Would it be the 2nd of January 2028? Or latest by the 31st of January 2028? Think about that. I have one celebration to do before I move on to get us to discuss our topic this afternoon. Now, the Community and the Law is live on BWTV, and this network is helping so many people to get to grips with the knowledge and experiences we share from BWF solicitors. Administrator and of course the marketing person for the channel is a year older today.
60th birthday, Uncle Ben. Working with
Remain anonymous, but unfortunately, I won't let her be because she does a lot for the channel, and we're so appreciative of her. So Sheila, thank you very much for what you do. We wish you a blessed day. May your new year and the years ahead be as fruitful and as successful as you want them to be, and as we want them to be for you as well. Congratulations on your new age. Thank you very much. Happy birthday to you, Sheila Ankra, our admin and our promoter for the channel. Well done, and we bless you for all you do for us. God bless you, Sheila. Thank you very much. Happy birthday to you. So on behalf of everybody, maybe I'll go to Laura Charles Asma, and on behalf of BWF solicitors, we wish our dear sister a happy birthday.
Yes, on behalf of the senior partner, senior management, entire staff of BWF solicitors, both UK and Ghana, and on behalf of the multimedia team of BWF TV, we want to say thank you and want to say a very happy birthday. You've been amazing. Your skills, knowledge, and talent, your time, all the resources you have, you put at the mercy and say thank you so much on this day. May all the remaining dreams come true, and we'll be happy to celebrate with you. Enjoy your day and have a very, very happy birthday.
Well, thank you very much, Leasma. I know she will text me later on. Oh, look, you didn't have to do this. No. We can't avoid celebrating you. We love you so much, and we appreciate what you do for the channel. So we're happy to have you on the team. BWF Solicitors is proud to have you on the team, and we want to say keep doing what you're doing. Congratulations on your EU age, as I said. Happy birthday once again. We'll take a break quickly, and when we come back, we'll delve into the discussion. Critical success factors in appeals. Leasma will take us into that.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Welcome back and thank you for sticking around. Let me see if I have a few people online that I need to acknowledge. Kudu Boating, good day, Brakweku and Loyasma. Thank you, Kudu, for sticking around. Tilly, please kindly share, comment, and like. Thank you very much, Tilly, as you are thanking us as well. Next, we have Sandra Fraser. She does what she does. Good afternoon. Or please share when you join. She has provided the contact details and the directions to BWF solicitors. Simply put, get yourself on the underground Victoria Line to Seven Sisters, exit number 2, breaks you the frontage of Anna House, climb up to the 4th floor, and you are there. If you're lost or anything, call 0208 493 7340. Thank you, Sandra, for doing this for us. And I think last month, Opusco de Dawn, I will read yours before I do this. That is my faithful lawyer, Mr. Charles. Thank you very much. Last week, I had my dear sister, Annie, sitting in for me. Can you please join me to say thank you to her because she did quite well and made me feel quite comfortable, even though I was away. I didn't have to look back because I knew I was in competent hands. So Layasma, thank you, and say thank you to Annie for me as well.
Sure. Yes, Annie did so well the last time. I almost forgot that it wasn't a masculine voice I was hearing. It was after the show that I realized that it was Annie instead of the usual host, Brakweku. And so she has been able to fit into your shoes, and your mentorship has worked, and she's doing so well. And I want to say that, Annie, keep doing what you are doing. Definitely, you've been a wonderful cover for our professor himself. So keep doing that. Well done. And of course, the entire admin team, Pamela has been doing well as well. She's been hosting in the past, and now everybody. So the entire crew is wonderful. The professor himself, Professor Dai, of course, will not be enough. So we say, well done to everybody and kudos. Let's make it happen for the community always.
Thank you very much. And my indefatigable producer would make sure that everything is on point. So I was quite sure things were going to go well. Well, Annie, once again, thank you very much. Now, ladies and gentlemen, let's sit back and get into the discussion. Critical success factors in immigration appeals. I believe that if you want to do it right, you do it the right way and follow the right steps. What are the steps we need to follow? What are the things we need to put together so our appeals are quite successful and granted? And then again, who does it? Who should do it? And how do we do that? I believe all these questions are things on your mind when you saw the topic, and you would wish that Lawyer Charles Asma helped us to do that. So this is the time to do that. Sit back, get your notepad, get people to get ready, and let's go into it together. Lawyer Asma, appeals, immigration appeals, so to speak. Do they normally fail? Is there any concern that we are having that we'll have to bring up so people do know what it is that they have to do?
Yes, definitely. Appeals are part of the whole package of getting your visa granted. And there's a reason why appeal is there, because it offers remedy. So that if you don't get it the first time, you can appeal to a higher body for them to look into it for you. And so, in terms of visa applications, there are appealable decisions and decisions that are not appealable, and they may be reviewable. So appealable means you go on appeal. Reviewable means you go for a review. Which ones are appealable? Which ones are reviewable? All family life applications or human rights applications, including asylum, are appealable. Unless the appeal right has been taken away, what we call there's no grounds of appeal. In other words, there's something what we call realistic prospect of success. If there's no realistic prospect of a success, then the appeal right may be taken away. But where there is possibility of success, then you have the appeal right. But some visa application refusals do not have appeal rights. Example, visitors visa applications, when they are refused, no appeal rights and no review rights. The only review you have will be judicial review, which is a standard review for to get a remedy. Again, student visa applications, usually you will get a review, administrative review. Skilled worker applications or work visa applications, you get review. So these are different categories. And UU applications, you get appeal and sometimes review. But whatever it is, you'll be told what remedy you have in terms of exploring further options. For today, we are looking at appealable decisions and where you've been given right of appeal as a way of remedy. How do you pursue that? And we are looking at critical success factors in appeals to do with UK immigration visa refusals. So when we say critical success, we are looking at what are the critical factors that will make you succeed at appeal when you have been refused a visa. So we are going to look at the rule book that the court will rely on. We also look at the reason why you want to go to court, and we look at what you have in your hands to be able to succeed in court. So the rule book is and mind you, at this stage we are looking at first tier tribunal. So once you are given right of appeal, you go to the first level immigration court, what we call first tier tribunal for immigration appeals. And if that doesn't work or you don't get what you need from there, you go to the next level, which is upper tribunal, upper tier tribunal, upper tribunal. If you don't get that, you go to the court of appeal or court of session. If you don't get that, you go to the Supreme Court. And if you still don't get that, leave it to God. God, that is the end.
That is the end,
Yeah. So, yeah. So, but at this level, we are looking at the basic appeal going to the first tier tribunal. And we hope that the first tier tribunal judge will agree with us and give us what we want if we've been able to follow the critical success factors to get it right.
Right.
Now, we start with the rule book from the court, what we call first tier tribunal rules 2014. Producer, get that for us. But before that, well, let's look at why somebody want to go to court to appeal against a decision. What it means is that the person is not happy with the decision by the caseworker to refuse their visa. And if they are not happy and they have good reason why they disagree, you go to a referee, which is the judge, to look into the matter to see whether they got it right or they got it wrong. What do we mean by they got it wrong? They got it wrong because they may not have followed their own rules or policies to making the decision, and therefore the decision will be unlawful. If it is unlawful, it's unlawful in the sense that it doesn't follow immigration rules, unlawful in the sense that it doesn't follow immigration act or laws, unlawful in the sense that it doesn't follow the Home Office its own guidance for case working practice. And if all these are put together, you can pick from there that this is what they said and it's incompatible with the appropriate guidance, then it will be unlawful. Then you can go to court to appeal to a first tier tribunal judge. So, what would the first tier tribunal judge be looking at in terms of the key rules the court will follow before we come to even what you have to look at in bringing your case? So, let's look at what the court will be getting ready for. So, producer, do you have the first tier tribunal rule book 2014, right? So, 2014 first tier tribunal procedural rules 2014, and we have part 1. And here we go. Let's ignore the first one, rule 1, and go to rule 2. Rule 2 deals with overriding objective. And the overriding objective is that every party to the case must be fair, must be treated fairly, objectively, and should feel happy that they've gotten what is fair from court in terms of time to do what they have to do, and in terms of whether they should be given undue time at the expense of the other party. So what we call the overriding objective. So the overriding objective is that there should be fairness in making sure that the case is managed by the court so that everybody is happier. All right. And this includes, if you are late, what do we do? And if you are not late, what do we do? And all these things. So let's go to 3. 3 deals with delegation to staff. Delegation to staff is where, apart from judges, there are people who work with the court, what we call the court clerks. The court clerks sometimes will make a decision on behalf of the court, and their decisions would have been made by delegated members of staff within the court. That's the judicial system. And so, if a decision has to be made by a clerk, what we call the tribunal legal officers now, then they will say that a decision has been made by a tribunal legal officer. You can appeal to a judge to make a decision. For example, you send your application and you are late. They can say that you are late, and you don't have to have a judge to look at it. They can dismiss it right away for you. So those certain decisions can be made by delegated staff within the first tier tribunal system. Then 4 is to do with case management, and where the court has case management powers to make sure that the cases are managed properly so that everybody is happy. And here we are looking at timing, we are looking at the cost, we are looking at bringing your evidence, we are looking at admitting the evidence, we are looking at further evidence, we are looking at opportunity for people who cannot speak English to be given opportunity of interpretation or interpreters. We are looking at all those requirements, flexibilities, and it is that power is with the judge or the court to exercise. And when they exercise, that means that in the interest of fairness and in the interest of the overriding objective under Rule 2, the judge will use a particular power to do A or B for a party in the proceedings.
Can I ask a question
Sure.
briefly, if you don't mind? Now, the case management, does it happen before the case comes to court and people are present in the courtroom? Or when the case is called, then the judge will ask the lawyers to go and agree on certain things in the case management situation?
So case management is to do with anything that will call for intervention of the court before the matter goes for hearing.
Okay.
For example, somebody is late and the other party is saying, why should they be given opportunity to bring their case forward if they're already late? Then the judge will have to intervene at this stage, exercising its powers under Rule 4 to say, yes, they are late, but we give them the opportunity to go ahead. So the court will have to exercise that power to give you clemency or to give you sanction. And here it's pre-hearing activities, including when to be notified of when to bring the bundle or your evidence, when to be told to bring requirements that you need, and anything. And where there are issues that need to be addressed, the judge or the court will call for a meeting. It's part of the case management powers. So anytime you are invoking that power or rule, you tell the court that, yes, my court, you have the power under Rule 4 to do A, B, C. And so I implore you to do so as you please. Case management powers.
Okay.
All right.
All right.
Okay.
Yeah,
Then
we can go on with it. Yeah.
we move on to applying or giving directions. So sometimes court will give directions. Do this, do that, do this, do that, and you have to follow them. If you miss any direction, that will go against you. So let's be mindful. So today we are discussing critical success factors. And such success factors also stem from the rule book that the court will use, which is the Procedural Rules 2014 rules. Failure to comply with rules. If you fail to comply with rules, then you are going to be punished for it. That is sanction. Unless there is a reason why you should be pardoned from that sanction, you'll be sanctioned. And sanction could be that they will not accept your appeal or they will strike out your appeal. Then striking out appeal. For example, you are supposed to pay the fee within 14 days you didn't pay, they will strike it out. Means they will dismiss, they will take it, they will throw it away before it goes further because you didn't pay the fee. What it means is that if for any reason you want the court to reinstate the strikeout appeal, then you have to apply to the court for them to consider it's the powers within Rule 4 to give you consideration to reinstate if you have good reason. Right. Now let's go to 11, calculating time.
Mhm.
Calculating time. So you have to submit your appeal 14 days of decision from the Home Office of refusal if you are in the UK, or 28 days if you are outside the UK. If you don't do it within 14 days or 28 days, your appeal is late. And if you are bringing a late appeal, you have to give permission, you have to seek permission for it to be accepted, what we call application for extension of time to appeal. Why were you late? Is it sickness? What is it? What is it at all that you didn't follow the rules? And if you didn't follow the rules, then your appeal will not be accepted. So one of the critical success factors is that make sure your appeal is submitted on time. 14 days if you are in the UK, or 28 days from the date the visa was refused if you are outside the UK. Let's bear in mind. Again, in terms of time, once you submit your appeal, Home Office has 28 days to provide their evidence. Then you have 42 days to provide your evidence. The process of providing evidence by the appellant or you is called case building. So you have to build your case latest by 42 days from the date of submitting your appeal. If you are late to provide your evidence, court can dismiss or can refuse to accept your evidence. If the court refuses to accept your evidence, that means you have no evidence to rely on in court. Then you are dead on arrival. So let's bear in mind critical success factors. So we have looked at two aspects of time: time to file your appeal and time to provide your evidence. And if you run out of time, what you must do by applying to court for permission to do that which you needed to have done. If you fail to seek permission from court, then court will not entertain such rudeness as to fail to seek permission and also not complying by submitting what you have to submit on time. Now, we're also looking at evidence gathering. And the evidence gathering is an important aspect of the critical success factors. So we
Okay.
have looked at one, the court will follow their rule book. So make sure that you understand the court rule book and follow it as well. Number two, we have understood the timing. 14 days to submit your appeal to court from date the visa was refused if you are in the UK. 28 days from the date the visa was refused if you are outside the UK. 42 days to send your evidence to court from the date you submitted your appeal, and also 28 days for Home Office to submit their evidence to court as part of the process. And once all these are done, we know that we are waiting for court to give a date for the hearing. In giving the date for the hearing, the court will want to know if you have specific requirements, if the date will be favorable to you, if you need interpreter or hearing aid or anything like that. They will ask you and you have to provide your requirement. If you don't provide the requirement and you go to court and you ask for some support, they will not listen to you because they gave you opportunity and you ignored. So all these things are important. Now, if we look at, for example, Rule 17, Rule 17 deals with situations where you think that there's no need to continue the appeal. In this case, you can withdraw your appeal. We don't need that bit because we are looking at appealing to the end. So why are we going to withdraw? So Rule 17 will not be applicable in this conversation. And also, appeal can be treated as abandoned. If you don't respond, if you don't do anything about what is going on, you don't comply, it will be considered as abandoned and it will be treated as ended. So let's bear in mind. Now, paying the fee, we have already mentioned that. Then we go to Rule 24. Let's touch Rule 24 quickly. Rule 24. Um,
It says response.
okay, yeah. So response, and I think let's go to 22. So where the court will accept late notice of appeal. And 24, we are looking at instances where the court will accept the evidence and the evidence must not be repeated. If Home Office has given a particular evidence, then you don't have to repeat it. So make sure whatever evidence you are giving has not already been given to court by the Home Office. That is why Home Office will bring evidence first before the appellant will bring their evidence. Now, we've understood all this. If there's no question here, we'll move on to the next success
Well,
factor.
there's one critical question I wanted to put across. The timing is of essence and is critical as well. Home Office refuses your application. You have 14 days within which to respond and file an appeal. Then for the appellant, you have up to 42 days. And for the Home Office, they have up to 28 days. Can I confidently say that when it's refused, 14 days and my 42 days is the least expectation that I would have to wait for?
Well, the question is not clear. What do you mean there is please?
Now, what I mean is, I should have at the back of my mind that whatever it is, it won't last anything earlier than 14 days and 42, which is what, 56 days.
All right.
I should have in mind that whatever it is going to go beyond 56 days or even 60 days.
I get what you mean. So there are two sets of dates.
Mhm.
The first date is filing your papers to court.
Right.
It has nothing to do with filing your evidence.
Okay.
So filing your papers, your appeal is saying that I'm not happy. I want to bring an appeal before the court.
And that should be done within 14 days.
14 days if in country. If you are in the UK, you are living in the UK, you have been refused.
Okay.
If you are living abroad and you've been refused, you have 28 days. That is times 2.
Okay.
Just because of the distance.
Mhm.
Yes. So that is and here, this date is not for the Home Office. Who is it for?
It's for the appellant.
The appellant, the person who has been refused a visa. So if you are refused a visa, 14 days if you are in, 28 days if you are outside the UK. Not that you are in. Please, let's bear in mind, it's not you are living in the UK and you traveled. Of course, if you traveled and your visa has been refused, then you can't even come back. So that one we know. So if you are abroad and you applied and the visa has been refused, you have 28 days. Bear in mind. Now, so you've complied, you submitted within 14 days or 28 days, and you have to file your papers or evidence now. Evidence. That's the case building. Case building. Now, in this case, how many days do I have to submit letters by? You, the appellant, have 42 days from the date you submitted your appeal.
Okay.
It doesn't include the 14 and 28 days.
Okay.
Because the 14 and 28 days is what you had before you submitted the appeal. Now that you have submitted the appeal, you have from the date you submitted the appeal up to 42 days
To provide evidence.
to provide your evidence, the evidence you want to rely on, including your statement, your argument, and all the paperwork that will form basis of your evidence to support the claim you are making.
Okay.
Now, before you send yours, Home Office that refused your visa must submit theirs.
Okay.
The Home Office has 28 days to submit their evidence.
From the time you filed the appeal.
Very good. So they have to bring theirs first. So the question is, if Home Office doesn't bring their evidence, does it mean I have to wait forever? The answer is no. Keep to your 42 because you have 42. Whether they do it or they don't do it, make sure you do yours by 42 days. Home Office has 28 days, but don't wait for them. Do yours. That's all. Now, we'll come to the evidence itself as part of the next critical success factors.
Yes.
So once we know what the rules say, our job is to comply with that or keep to that. Now, in sending your evidence, again, in sending your appeal, you are going to be told, do you want the judge to make the decision without you, or you want the judge to make the decision with you? What do I mean with or without you? Would that you means that the decision will be made on papers? So you send your evidence, and the judge will sit in his or her room and make a decision based on the papers you have submitted. We call it paper hearing, paper-based hearing.
Okay.
The risk is that you are not there to appeal to the conscience and the mood and the heart of the judge.
Okay.
And so the alternative is oral hearing, where you go in person and the judge will make a decision with you. Not that the judge is going to ask you, what do I say for you? But the judge will ask you some questions by way of follow-up. The judge will listen to you when you are cross-examined by the opponent's lawyers. The judge will hear you when you are examination in chief by your own lawyers. The judge will look at your body language, look at your mood, and conclude that you are a credible witness or you are not. Credible witness means you are truthful. And once the judge concludes that you are truthful, that is about 90% of the job done. And if the judge also thinks that you are not truthful, that is also going to go against you. The question is, should I go for paper hearing or oral hearing? I would say go for oral hearing if you have nothing to hide. So that at least they know that you have come. It's your case. You are the main witness. Go and speak so that the judge will understand that you have nothing to hide. But where you are not comfortable appearing, then you say, Judge, you know what? Do whatever you want to do. I've given you all the papers. And the judge may decide that, well, they can't even be bothered. Let me make a decision. It doesn't mean that the decision is not always going to be, it's always going to be favorable. Sometimes you are not there, but the decision can be favorable. But you have a choice. If you are going on paper based, it's £80 court fee. If you are going on oral based, it's £140 court fee.
Is there any significant advantage one could have over the other? For instance, you mentioned that when it's oral based, you could be in there, could be cross-examined, your evidence in chief could be looked at, your body language, your demeanor may appeal to the judge and all that. If I am doing the paper-based one and I've cogently put my argument on paper, would any one of them, or either of them, so to speak, have an advantage over the other?
I mean, this is a simple question where you ask me, do you want your food to be delivered to you by Uber Eat drivers, or you want to go there and order and wait for them to cook for you?
It will depend on the person.
Exactly. And
Their
therefore, whether
choice,
you
their
want
convenience and everything.
exactly, so whether you want oral or you want paper, it's up to you. But if you ask me my professional opinion, I would say that if you have nothing to hide, go in person, and that adds value to everything. But if you are not sure about yourself, then don't go and contradict yourself.
Okay. Well, if you just joined us, we're looking at critical success factors in UK immigration appeals. Loretos Asma from BWF Solicitors is helping us look at the things you need to really look at when you have been refused and you want to go for an appeal. He mentioned earlier on that there are cases that are appealable and cases that are not. If you are refused and you are in country, you have 14 days to file the appeal and up to 42 days to put in every evidence that has to be put in. If you are outside of the country and you made an application, it was refused, and you want to appeal, you have 28 days and then up to 42 days to supply the evidence. The Home Office, from the time you file the appeal, has 28 days to respond. Evidently, is saying that they will have to respond before you would bring up everything that needs to be done, and the judge will set a date for the hearing. We're still looking at some of the factors. He's taking us to the rule book and we're going through it step by step, and some of the things definitely you need to look at. But I want to say that we have to say thank you to BWF Solicitors for giving us this opportunity to learn this way, and also empowering us as individuals within the community when it comes to matters of the law. BWF Solicitors is on the 4th floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters, North London. 0208 493 7340 is your telephone number. If you're in Ghana, 055 589 5959. And in all emergency situations, 077 127 61884. Remember, they work Monday to Friday between 9:30 in the morning and 6 p.m. This is their message.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you very much, BWF Solicitors, for all the help and the opportunities you give us. We're live on BW TV, and we're coming your way with the community and the law. This afternoon, our guest and resource person, Lawyer Charles Asma, is helping us through critical success factors in UK immigration appeals. We've gone through the first part. We're going to look at what an actual situation may look like and what to look for as far as the critical success factors are concerned. Lasma, yes, you've taken us through the rule book. We have understood what it is that we need to look for, but in real life situation, what could it look like really, literally as well?
Thank you very much. So the next thing is to look at the decision under appeal, which is the refusal letter. The refusal letter is what the person is telling you, the claim the person is making, or the allegation the person is making, and your job is to rebut the allegation or to counter the allegation. So the question, when you are going to court, on what basis are you going? You are going because you disagree with what the caseworker is saying. And if you don't understand what the caseworker is saying, then what issue are you dealing with?
Okay.
So the next critical success factor is to understand the reason for the refusal and look at ways to challenge those reasons.
Okay.
And how do you do it? You read carefully, deliberately, and painstakingly the decision and the review.
Well, that is what I'll call the strategy, isn't it?
The strategy. Okay, so producer, share with us. And this is a case where this is a fresh. Our person here has just been refused. He called me, Lawyer Charles, I've been refused. Is it 20th? Yesterday, right? So yesterday he sent me this, that lawyer has been refused. The people say blah, blah, blah. What are we going to do? I said, read through. I'm also going to do the analysis, make a decision, but we have to file. He's in the UK. So how many days do you have to send this to court, appeal?
Well, 14 days.
Fantastic. You are a very, 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 very knowledgeable student. Good.
Right. Thank you.
Right. Yeah, so
Okay.
14 days from what date?
From the date the refusal was made.
Don't go far before you.
Well, it's on the 20th of June. And that's what it
20th of
says.
June. That's the relevant date.
Mhm.
Right. So we count
So
14 days from 20.
14 days would be 10 days to the end of May,
June.
June, sorry. And then 4 days, that will be the 4th of July,
4th
2025.
of July, you have to send. If you send it by 6th of July, are you in time or out of time?
You're out of time.
And what do you have to do if you still want the court to accept?
Then you would have to let the court know the circumstances under which you were not able to send in the appeal on time.
Good. And that is called application for extension of time to appeal. And the judge or the court will rely on Rule 4, case management powers, and Rule 2, overriding objective, to see whether it is fair to give you permission to continue or not. Right.
Okay.
Good. Now, so we are going to look at the background, look at the reasons, and identify the key things they are saying. Those will be the issues. So the reason why you have to read this is that they have said a lot of things that you may not be happy about, based on which you've been refused. Do you agree or disagree? And if you disagree, what are the issues that you have picked up that you want the court to determine for you? Right. So the next factor is that read the refusal letter carefully to identify the issues that you want the court to determine for you. So let's read. Brakoku, off you go.
Well, the introductory bit says that thank you for your application under the EU settlement scheme. It has been carefully considered, but unfortunately, from the information and evidence available, you do not meet the requirements of a scheme. I'm sorry to inform you that your application has therefore been refused. The rest of this letter details the reasons you have been refused, what you can do next, and the help available from us. So then they outline the reasons. We have considered whether you meet the requirements for settled status, also known as indefinite leave to enter or remain, or further pre-settled status, also known as limited leave to enter or remain under the EU settlement scheme. Unfortunately, based on the information and evidence available and for the reasons set out in this letter, you do not meet the requirements. To qualify under the scheme, you need to meet the requirements set out in Appendix, can we scroll up a bit for me? Appendix EU to the immigration rules. You can find out more about that, and the link is given. But it goes on to give the immigration history of this appellant. On 22nd of June 2012, you applied for 6-month visit visa. This application was refused on the 12th of July 2012. On the 2nd of August 2012, you applied for 6-month visit visa. This application was granted on the 30th of August 2012, valid to 28th of April 2013. Next, it says on the 6th of January 2021, you applied for pre-settled status under the EU settlement scheme as the spouse of that, and this application was granted on the 8th of May 2021. 2024, 9th of October, you submitted your current EU settlement scheme application as a spouse of XYZ. The consideration of this application is below. Yes.
Now go to the chronology. Go back to the history.
Yes.
So here you have to pause because our aim is to identify issues.
Okay.
Think carefully, not you. So it's your job now is to think about why is the person referring to my history with a view to say something. They say, you came as this, you did this, and you made this application. What are they trying to say? All they're trying to say is that because you want to remain, that's why you went into what you did to be able to get a visa to stay on.
Right. Okay.
You see? So they are now referring you to your history to make a case out of that. So you have to make a note of this so that you say that, yes, I agree that I came in on this date and this and this and that, and I remained, I started a relationship and that. However, remaining and starting a relationship is not with a view for anything, but as every human being would desire to have a life with somebody that I'm compatible with and I can have a meaningful permanent life with. And that is why I did what I did. And to be able to do that, my partner sponsored my application, just like any responsible partner would do, so that the other partner will be comfortable and to go about life without fearing of immigration control. And that is why I did. Contrary to what you think, that I stayed on and I went into the relationship because I wanted a visa.
Okay. Now, then I would ask, these bits have been redacted, but I'm asking if, for instance, on the 6th of January, this person applied for pre-settled status under the EU settlement scheme. And then we go on to, on the 9th of October, another submission was made uh, applying for EU settlement scheme. The previous one is pre-settled. This is settlement. If there were two different people with those applications, could that be doubted and said that, well, you applied pre-settled with A and you have applied settlement with B? Would
All
that
right.
be used, or would that be of consideration, really?
A good point. But the key thing is this: pre-settled is the first visa, and the settlement is actually the
Indefinite.
settled status.
Mhm.
So this person applied, and when after 5 years they think they were due, they applied for settled status or settlement or indefinite. And
Mhm.
therefore, it is not possible that you apply for pre-settled with your first wife or husband, and you apply for indefinite with another husband or wife because you remarried. It would have been a continuous, just as this one was continuous.
Okay. All right. All right. Then we can continue to look at what the further reasons were, can we?
Right. Yes. So, and now it says eligibility. So eligibility is pure law. So I'm just going to go through that.
Okay.
There's no issue on eligibility, because to qualify for indefinite leave to remain, you have to show that you have lived in the UK for 5 years, or you've stayed on in 5 years pre-settled status for 5 years, and
Mhm.
and that is so. EU 11 describes the timing to be eligible for indefinite, and EU 14, paragraph EU 14, deals with timing for pre-settled. So if this person had not lived in the UK after from marriage date in the UK for 5 years, they would have said that you are not eligible under EU 11 because you haven't done 5 years. But because they've done 5 years, they said that careful consideration has been given as to whether you qualify for certain status under EU 11. You state, then they come to remind him. So, so this person is applying without a wife. And how do I know that the person applied without a wife? Go to the second paragraph.
Um, you state that you are a family member who has retained the right of residence by virtue of a relationship with a relevant EEA citizen on the basis that you were previously espoused to a relevant EEA. However, you have not provided sufficient evidence to confirm this. The reasons for this are explained below. You provided a
So,
marriage certificate
so
dated the
can we
4th of
pause
October
there?
2019.
Can we pause there?
Yes.
Because we're identifying the issues as we go along. So this person applied under retention of right because there was divorce at a point.
Okay.
And so at the time he was due, or she was due for indefinite, the person was not living with a spouse, the EU national.
Mhm.
And that's why they said that you state that you are a member of an EU national who has retained their right, retention of right, by
Mhm.
virtue of the relationship with that person. However, you have not provided sufficient evidence to confirm this. And what do we mean by sufficient evidence? So we have to pick this up and say that the caseworker alleges that in my attempt to apply under retention of right under paragraph under regulation 6 under regulation 10 of regulation 16 and all that, blah 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 blah, I have not provided sufficient evidence. I do not understand what the caseworker means by sufficient evidence, because it is not defined what is sufficient. I know that my wife and I divorced, and prior to divorce, we had this, we had that, and after divorce, I don't have anything. She couldn't attend the interview because we're no longer together, and I told them the reason why she could not be there. Blah, blah, as part of, so you see, anytime you are picking, once you pick up the issue, you note it down and think about how do I address this in my argument and also my witness statement, and also gather evidence to support that. Right. So go to, you have provided marriage certificate.
Yes, you provided marriage certificate dated the 4th of October 2019 and the final order dated the 9th of June 2023 as evidence that you were previously the spouse of an EEA citizen. The Home Office has obtained evidence in the form of your current passport issued on that date. However, your 6-month visa expired on the 28th of February 2013, and the Home Office record showed you next applied for leave to enter or remain in the UK on the 6th of January 2021, which indicates that I think that's what it's supposed to be. You remained in the UK as an overstayer when your visa expired. Based on that information, we have reasonable grounds to suspect that your marriage with the EEA citizen is one of convenience, entered into as a means or to circumvent the requirements for lawful entry or stay in the UK or Ireland.
Full stop.
Enable the secretary.
Oh, hold on. Okay. Hold on, so that this is the eureka moment. This is what we are looking for. What is the reason for refusing this person's application? And what's the reason? Their reason they have mentioned is that this is a marriage of convenience.
Convenience, yeah.
So you pick that and you have to address it. So one of the issues for determination will be whether the appellant's application for settled status or appellant relationship with their spouse, their ex-wife or husband was one of convenience or not. And it's up to the court to determine that. So you support your argument with evidence. What evidence do you have to show that the marriage was not one of convenience, but a genuine and subsisting relationship with a view to a permanent life, albeit there was divorce, which is part of life anyway?
No, so in this case, the Home Office is now accusing this person of getting into a marriage of convenience. Is it not up to the Home Office to prove this, rather than him coming with evidence to counter that?
Good point. Now you are with me. And that is why we are saying that once you have identified the issue, your job is to find the argument to the issue. So what you are saying is that it's marriage of convenience. So you then point it out that the caseworker alleges that my marriage is one of convenience. I disagree, because I will not do X, Y, Z. And it was a genuine marriage, albeit we became incompatible because of X, Y, Z. However, the secretary, the caseworker did not prove otherwise, other than relying on my interview. So the person was invited to attend interview as part of the evidential flexibility rules that come and prove that you and your partner's relationship is genuine. But relying on interview alone is not enough. There should be more than that. And therefore, if you look at the case of Papa Georgie and the case of Sadowska, they say that in alleging marriage of convenience or in alleging sham marriage, the onus is on you. This is me. I've given you why I gave the answers I gave at the interview. And you haven't given me anything apart from the interview answers to show that the marriage is not genuine or was not genuine. So prove it.
Well, they'll have to prove it against your evidence in any case. So we'll wait for what they will bring.
Right, and Bragoku, in proving that, they will examine you in court, what we call cross-examination. They will interview you in court. Yeah. So the Home Office lawyer will interview you in court to support the argument that they think the original relationship was not genuine one, even though there was marriage, which was genuine, but the intention for going into the relationship will not be one that is genuine. And that is what they will be seeking to get from you. And your job is to make sure that you answer all the questions truthfully, factually, and in detail where necessary, to convince the judge that, look, that is what they think. But from what I'm saying, it is contrary to that. And so I cannot be accused of XYZ, and so they have to grant me my visa.
Yeah. So moving on, they have, as you mentioned, invited them for an interview in April. There were observations from the interview, and the letter is saying they covered the immigration history, the relationship and marriage, residence or cohabitation in the UK, the considered family, treaty right, sponsors medical issues, and then they outlined what they think of the relationship breakdown.
So,
Yes,
yeah, Bragoku,
yes,
Bragoku, because of time, you just read the headings, and I
yeah,
will add one liner to it, and we'll move on so that we can go to the next stuff. So
right.
just
So,
run through.
talking about the relationship and its breakdown, what's the Home Office alleging?
So the Home Office is acknowledging the fact that the relationship broke down. And the moment the relationship broke down, leading to divorce, the person is right to still apply under retention of right, Rule 10 of Regulation 2016.
Okay,
Yeah, because if the relationship is broken down and it is not a EU marriage, then it is no longer subsisting.
that's right.
Then it will against you. But under EU, even if the relationship is broken down and it is no longer subsisting, your right would have been retained and it will not be used against you.
Right. So
Yeah.
then, after the relationship breakdown, what else are we looking at? Let's go up and pick up the next line. It's talking about relationship and marriage.
Yes, so the relationship and marriage. So they just want to be sure that the marriage was there, the relationship was there, and everything pointed to the fact that the relationship was subsisting at the time.
Right.
So each of the paragraph they have raised, your job is to rebut them in your witness statement and your
Okay.
skeleton
Yeah.
argument.
But they brought back again the customer's immigration history.
Mm.
Are they trying to make that one major point?
Look at the last paragraph. Taking together the above actions suggests a pattern of behavior that disregard UK immigration requirement, undermining
The
uh,
integrity of the immigration
integrity
system.
of the immigration system. So what they are saying is that the person became an overstayer, stayed on, and switched to marry and stayed on under 5 years pre-settled. And so he was playing games with the system. But
Mm.
that is not a factual conclusion. That the fact that I was an overstayer does not mean that I could not form a genuine relationship.
Right. Then they drew their conclusions from the interview lawyer.
So the conclusion from the interview that putting together the inconsistencies and the discrepancies from the interview responses, it conclude that your marriage was entered into with a view to getting a stay in the UK because you were an overstayer. But
Okay.
again,
So
we have to rebut that. Your job is to rebut that. Hang on, that is a one conclusion. Yes, there might be discrepancies, and whenever there is a discrepancy, you have to give reason. Because if this was done virtually, check whether the person spoke English, whether there was interpreter, whether the person understood all the questions, the person's mood or emotional state at the time, and whether IT issues impeded the person's ability to understand the question and to give clear explanations. So discrepancies alone should not be the basis to conclude that there is marriage of convenience, unless there's some corroborative evidence pointing to the same fact.
oh, okay. So the Home Office would have thrown this at the appellant, and then not agreeing with that would ask that you help appeal to this. So what will be the next steps?
Right. So the next steps that the person, let's check. Has the person been given remedy to decide whether this is an appealable refusal?
Mhm.
What
It
did they
says you
say?
can appeal this decision to the first tier tribunal under the Immigration Citizens' Rights Appeal EU Exit Regulation 2020. If you're in the UK on the date of this decision, you have 14 calendar days after the date of this letter is sent to appeal. If you're outside of the UK on the date of this decision, you have 28 calendar days from the date you receive this appeal, which you have explained earlier on.
Okay, good. So it's clearer now. Now, so the exercise so far is to look at the issues. So there are two issues here. One, so the issue for determination will be that one, whether the appellant is a family member or was a family member of an EU national. And two, whether the appellant's relationship with that family member was genuine.
Mm-hmm.
And three, whether the appellant was able to apply or whether the appellant could retain his right despite the absence of the spouse in his life at the time of application. You see, so these are three issues we want the court to determine, and we have to address each issue based on the law we are relying on. So you have to identify the laws. The first point of law that you are going to rely on is the retention of right, whether somebody has ability to retain their right. So you have to refer to the retention of right provisions for this person. Two, because if there's no retention of right, then application itself did not meet the rules. So you have to point it out. Number two, we have to look at rules governing marriage of convenience and sham marriages. So we have to look at case law, case of Papa Georgie, case of Sadowska. We have to make reference to that. And the duty on the Secretary of State or the caseworker to prove, because they are alleging. And once they have been able to swing the pendulum to the appellant side, whether the appellant has something to be able to prove that indeed theirs is not a marriage of convenience. So these are all based on rules. And also EU regulation. Now they've pointed it out. Regulation 2020, the Brexit law, the withdrawal agreement of 2020. That's also important law to rely on. Then we also look at Section 85, subsection 4 of Nationality, Immigration and Asylum Act of 2002, which says that in presenting your case before the court, you can bring new evidence which were not present at the time of your application if that new evidence is still is able to support your claim or is helpful to your case. So you are not just going to use the information you had before, but you can also use information that became available after the application date if that information is helpful to your case. Now, one of the things they picked up is that they said the person said the relationship broke down, and yet he was able to have evidence from the lady, bank statement and stuff from the lady to show that they were living together.
Mm-hmm.
His explanation is that no, it's not that we were living together and I'm saying that we stopped living from 2022, but is that we were sharing accommodation. And due to whatever happened, she left home. I was trying to locate her. She blocked me at a point, and it was difficult to find her again. I was asking around from friends and family members I knew. And because we were still living there, her correspondence letters were still coming to the address.
Okay.
So it's not that she was living still with me, but just like what happens when people move out and they don't change their address, they still receive letters. And so anytime the letters came, being a responsible husband, even though we are no longer together or the marriage had broken down, I was still keeping the letters for her. And that is why I presented to you to say that we were living together up to this point, and until then, that is it. It's not that I went to look for her to get these things, but that we were at the same address. And also to show that indeed we were living together until the unfortunate happened when she left home.
Well, the critical success factors we have been looking at, and I believe that we would have to shelve the rest for people to come over to see you because we need the visits as well. If you have any questions, you can text them to 07399208468, either on WhatsApp or on normal text. Or the lines are active now, 0208-493-7345. You can call us, and Lawyer Charles Asma will answer your questions. Or leave them in the comment section down below, either on Facebook at BWF Solicitors, at BWTV, or on YouTube at BWTV UK and at BWF Solicitors. Lawyer Asma is a resource person and guest this afternoon, I should say, from BWF Solicitors, our trusted partners when it comes to the law. If you need anybody to help you with all the details of the things that you need to have to know when it comes to the law, trust BWF Solicitors. In emergency situations, call 077 127 61884. Yeah, we'll go straight to your comments and questions. Lasma, with your permission, Kojo Martin is saying, is self-employed from the 1st of June 2025. The business gets income of about 6,000 cedis a month. Please, when filling visits visa application, it asks how much you earn a year. How much do I put, please? Trip has been paid for. That's what he says.
All right. If you are self-employed, as you have said, check how much their business earns a year.
Mhm.
But obviously, it depends on the nature of the self-employment. If it's a company that is different from you, you're the owner of the business, then you cannot say that this is how much you earn. So I'm not sure whether you are working for the business and the business pays you. If the business pays you, then your salary from the business is what you put down, because that's how much you earn. But if the business is paying for it, then of course, you can't say you. So I cannot say yes or no. It depends on the context. I will not be able to advise clearly on this. So if you want to put there 6,000 times 12 for the business, you can do so. But whatever you put there is not what is going to determine whether the person will get the visitor's visa or not. If the bank statement for the business are your personal bank account, and everything is in your name, then that is what you earn. You can put it down. But you put down what you earn is not the gross money, is the profit. So how much is the profit for the year? Check how much comes in. You said 6,000 a year times 12, which is about 72,000 a year. And expenses thereof. What is the net profit? That is what you put down as earning.
Okay. Well, we've got a person on the line, 0208 493 7345. Hello.
Hello, good afternoon.
Good afternoon. Last one, please, can you hear our friend?
Yes, I can.
Okay. My dear friend, can you hear Asma on the other side?
Yes, please, I can hear him.
Fantastic. Please go ahead with your question.
Yes, I am asking this question for my friend. Yeah, he's doing an indefinite application under EU for his son. The son was about 1.5 years ago arrested for phone robbery, and because he was a minor, he was released on bail on that day, and since then he has been reporting. So during the application, it gets to a place where they said the criminal conviction, whether you have been convicted, arrested, or awaiting trials. Does he have to declare that in the application?
So the person making the application is not the culprit or is not the guilty person, but rather his son. And are you asking if that is going to affect the application?
The son, yes.
Is the indefinite application for the son?
Yes, please.
Okay. Lasma, he's asking whether when the thing happened, this person was a minor, so was granted bail, and he has been reporting. Does he have to declare this?
Okay. My brother, how are you?
I'm fine, sir.
Good. Now, let's look at the question. Does the question say, have you ever been? Or the question says, this month or last year? Is it specific or open?
Come again?
What is the question? Does the question ask about an offense within a particular period or general question about offense?
Yes, and the general question and the offenses, have you been convicted, arrested, or awaiting trial?
Full stop. Hold on for me. So you see that's why what I wanted you to pick. Have you been? It didn't say have you been in the last 1 year? Have you been in the last 1 month? Have you been in the last 1 week? It says have you been, isn't it?
Yes.
What does it mean? There's no defined time.
Okay.
So you cannot say that I was a baby then, and that is 100 years ago. Because it doesn't say how long.
Okay, so meaning he has to take no.
That's not the question. That's not the point. The question is, is any of the following applicable to you? That's the question, isn't it?
Yes, please.
What's the first one? Have you ever been have you been arrested? Have you been convicted? Have you been Have you been? Has he ever gone through any of these things?
Yeah, because he has been arrested before. So
hold on for me, my brother. Has he ever gone through any of these things? Is any of them applicable to him?
Yes.
Yes. So the answer is yes. No if, no but. Then when you say yes, they will give you time to explain further. Okay?
All right. Okay.
Okay. All right. Thank you very much, my brother, for your call. We appreciate that. You can also call in 0208-493-7345, or you can leave that in the comment section below, as people have done. At BWF Solicitors, Facebook and YouTube, at BWTV UK, Facebook and YouTube. Eminence Ventures, I'm asking this for his daughter was arrested for alleged phone robbery, but I was sure the minor she was given. I think it's about the same thing this person has asked. We have answered that with and for our brother who called in. Thank you very much. So we can move on to another one. Adair Taribu is saying, I'm an EU citizen and I have settled status. My son is also an EU citizen who also has settled status. My son wants to bring his EU partner to live with him in the UK. Is there any way he can do that, lawyer?
All right. So this is not about him. It's about the son, right?
Mm-hmm.
The son has settled status. That means the son, but the son is not an EU national. My son is also an EU citizen. Oh, okay. It's also an EU citizen. All right. And they want to bring their partner. Yes, of course. The partner can come and join him in the UK, but the partner must meet the rules under EU. Because this one, but again, it depends on when they married. Even though this is under EU, it also depends on when they married. If they married after the cutoff period, which is 31st of December 2020, then the person became a family member after Brexit. So it will be normal immigration rules.
Okay, yes. So if you have a question, yes, as I said, you can send it via text or put it in the comment section either on Facebook and YouTube. Matthias from Pond says, a friend applied for EU permit in July 2024, but no decision yet. What may be the cause of the delay? What possibly could the decision be, or when possibly could the decision be made?
July 2024 is about a year. And family permit, that means from abroad. From abroad, that is true. I don't know whether the person is in country or, but normal family permit is from abroad. 1 year is extreme. So he has to follow up so that we find out what is holding it. He has to follow up.
Does he have to start with a PAP?
Yes.
Pre-action protocol?
PAP or complaint for unreasonable delay.
Okay. In those situations, is it ideal for a lawyer to do that on behalf of the applicant?
There's a good reason why some people opt for cook for me instead of cook for myself. So if he believes that somebody taking the burden will help him, then let somebody hold it for you whilst you rest and wait for them to deal with the matter for you. So whether you need a lawyer or not depends on you. It's good. There's good reason why lawyers are there to deal with such matters. But it's up to the individual to make the decision whether they need help.
Okay. Yes, keep them coming through. Comment section down below, text or call. The call number is 0208-493-7345 or text 073-9920-8468. Or then you can leave them in the comment section down below at Facebook and YouTube, BWF Solicitors and BWTV UK. Remember, I gave you a scenario in the nugget and also gave you the text for the question. Those who apply to renew their leave to remain in the UK risk delaying their 5 or 10 year continuous resident period to indefinite leave to remain whilst paragraph 39E of the immigration rules allows for extension of leave within 40 days of the visa expiring. Such delays and any subsequent delays up to the date of the renewal decision is made will be deducted from the qualifying period. So then we had a friend who had come in and faced with this scenario, entered the UK as a dependent of a British citizen. She was granted a 2.5-year leave to enter, expiring on the 15th of May 2025. She submitted her renewal application late on the 25th of May 2025 due to lack of funds. On the 15th of June 2025, she was granted another 2.5-year leave to remain, which is valid until 31st of December 2027. So the question I'm asking is, when should this our friend Jane apply for indefinite leave to remain? 1, latest by the 3rd of December 2027. 2, latest by the 31st of December 2027. 3, latest by 2nd of January 2028. Or finally, latest by 31st of January 2028. Which one would be your correct answer? Think about that. We still have a few minutes and moments to go. I'll take this break, and when we come back, we'll look at your answers possibly, and then round up with Lawyer Charles Asma, a resource person and guest from BWF Solicitors. It's the community and the law. Yes, Jane's scenario, Jane's situation, what do you have for her? She entered the UK as a dependent of a British citizen, granted 2.5 years leave to enter, expiring on the 15th of May 2025, submitted a renewal application late 10 days after because she didn't have money. On the 15th of June 2025, she was given another 2.5 years, which is valid until the 31st of December 2027. So the question is, when should Jane apply for indefinite leave to remain? Is it latest by the 3rd of December 2027? Is it latest by the 31st of December 2027? Or moving to the new year, 2nd of January 2028? Or the latest by 31st of January 2028? Now, remember paragraph 39E and 3C. All those situations, what 39E does for you, what 3C does for you, when you apply within 14 days after that, how do you pay for that, and the rest of it. Now, drop your answers. Let's see what you have. We have Kojo Williams says it's number 3, latest by the 2nd of January 2028. Sally Mensah says latest by the 31st of January 2028. We have Nana Bwediwa, latest by the 2nd of January 2028. That's number 3. We go on to Obecha says number 4, latest by the 31st of January 2028. Who else do we have? Dufia Credit. Dufia thinks it's number 4, latest by the 31st of January 2028. I wish if I had a chance, I could have given you all the chance to tell me why you're choosing any of the 4 dates. Obed Boateng both says it's number 2, latest by the 31st of December 2027. Beniza Setre, Beniza Setre Eben says it's number 3, latest by the 2nd of January 2028. Kwekujan thinks it's number 3, 2nd of January 2028. And then Solomon Adolfo also talks about 31st of January 2028. Which one is correct? Mavis says it's number 4, 31st of January 2028. And Emmanuel says number 1. Emmanuel from YouTube says is the latest by the 3rd of December 2027. Stephen Kwachi thinks it's number 1, 3rd December 2027. And maybe I'll take the final one and go to Lawyer. Clement Opon says it's number 4. Lawyer, we have 4 answers. Today I expanded the scope a bit. Oh, that two more. Okay, connect to four. I couldn't have skipped yours, could I? Number four, 31st January 2028, and finally, Tilly says it's number three, latest by the 2nd of January 2028. Lawyer, you have the verdict.
I'm very much impressed because the examiner, looking at the answers provided,
Mm,
very close, and they are all possible answers depending on where you sit with the law and whether you
right.
understand the case of Yeki and Afzal very, very well, the ruling by the Supreme Court as to
Mhm.
delay and the punishment.
Right.
So let's look at those who said or gave answers for 2027.
Mhm,
If we look at the date the visa expires, because this is a 5-year visa, first
mhm.
2.5 and the second 2.5.
Yeah.
First question: did the person apply within 39E or within 3C? We are told that the person was late, right?
For 10 days.
For 10 days. And how long did it take Home Office to make a decision?
Um,
20
applied
days.
May 25th and the 15th of June, which is 6 and 15 days, 21 days.
So 10, it's about actually, so I think it's about from the, if we situate them together, it works
Mhm.
out about 20 days.
Yes.
So that those 20 days plus the 10 days, 30 days combined delay, right?
Yes.
Accumulated delay. Who
Mhm.
pays for this accumulated delay? Is it Home
Yeah.
Office or the applicant?
The applicant.
And what does this delay mean? It means the person's indefinite will delay by 30
By
days.
30 days.
Right. Now let's look at this. The visa will expire 31st of December 2027. If not for the delay, the person will apply earlier, but we are saying latest.
Mhm,
Earlier means would be 28 days earlier.
mhm.
So if it is 28 days earlier, it will be 3rd of December 2027. But if they apply 3rd of December 2027, it won't work because the case of Afza means that they cannot because they have a delay to make up for.
Mm.
So that is out. And even that one will not be the latest, it will be the earliest. Two, the latest, if there is no delay, would have been 31st of December 2027, the last day of the visa expiring, isn't it?
Mhm.
The latest.
Yeah.
But
But
then
there
they
was a delay.
cannot because they were late and therefore they have to be punished for the delay. And so it cannot be when it expires. They have to make up for 30 more days. Then they come to the third one, latest 2nd of January. That means 31st of January, sorry, by 31st of
December.
December, they go into the next season. So the next season, if they were to wait for 30 more days, that would be 20, that would be 30th of, by 31st of, for example, 30th, 31st of January, isn't it?
Mhm. So
But
latest by.
but if it is earlier than if it is within 28 days, then it will be earlier of 2nd of January 2028 because they will then apply 28 days before the 30 days delay will
Okay.
end. That is why it's second. Then, however, we know that if they apply earliest by 2nd of January, it still means that they have deficit to make up for.
They have a 30-day deficit to make up
No, they don't have 28 days deficit
for. Okay,
to make
second,
up for.
yes.
Yeah,
Yeah.
and therefore the visa will be refused. And they will tell them that according to IFZA and IYAKI, they cannot bring the application on that date. And so they have to sit back and then ask, the 30 days I have to wait. When do I wait by? I have to wait by 30th of January 2028, isn't it?
Hmm.
Then the next day will be the latest date they have to apply, which will be 31st of January 2028. However, by that date, they don't even have a visa. So the next, we are not going to go into that. I was discussing, the examiner was going to bring another one where we look at the implication. But for the benefit of this conversation, let's
Hmm.
leave this. Let's bring it here. So that what it means is that because your visa has expired, by the 31st of December 2027, you cannot say you are waiting by 31st of January 2028 to apply. So the best thing to do is to apply for a top up 2.5 again to be able to keep you for 30 days and bring your
Okay.
application for indefinite by 31st of January 2028, the latest. So the answer is 4.
So the answer is 4. But then there's a caveat within there that you may have to find an escape route so that you don't become illegal within that period, isn't it?
Very good. That is the extended question. So what is the implication of this delay?
Okay. All right.
Very
So
good.
yes, a lawyer has explained that Sarah Jane was 10 days late in renewing her visa. The Home Office will take 20 days to decide, and combined delay will be 30 days, he has explained. Therefore, the latest date for Jane to apply for indefinite leave to remain will be the 31st of January 2028. Question 24 says, yay, that is 30 days from the 31st of December 2027. With that, we come to the point where Lawyer Asma will be doing us the honors of summarizing what we discussed today. Critical success factors in UK immigration appeals. Lawyer.
Thank you very much. So viewers and listeners, today we have looked at the critical success factors. To succeed, make sure that you understand the immigration rules. The immigration appeal rules, which is the the First Year Tribunal Rule Book 2014. And if a lawyer is doing it for you, the lawyer will follow that. If you are doing it yourself, make sure you understand the rules and follow. It's important. The second factor is that understand the reasons for the refusal and find a way to respond to each one. And the third one is that you have to always consider whether to go for oral hearing or paper hearing. And it's always better to go for oral hearing because of reasons that you want the court to the judge to see you face to face and relate to you and understand that you are giving credible answers or evidence. Then the next factor is that you have to situate your responses to the reasons for the refusal in your witness statement. Your witness statement for yourself. In this case, the example we had, there will be no witness statement from the wife, because the wife is no longer in the picture. So his own statement, and if he has friends and family who were privy to the relationship or marriage, he can get them from those people as well. So witness statement should be clear, detailed, and very, very on point to addressing those issues. Again, the skeleton argument, if you are doing it through your lawyer will prepare the argument looking at the law to support the argument. If you are doing it yourself, you have to prepare your skeleton argument, making sure that you are applying appropriate laws to respond to those issues. The next point is that in gathering evidence, apart from a witness statement, you have to bring your evidence. Evidence are documentary evidence. So you have to make sure that you select evidence that support your case and not undermine your case. And where it is not clear, you have to explain in your witness statement. These are the critical success factors that you have to look at to ensure that you succeed in your UK immigration appeal venture.
Well, thank you very much, Lawyer Charles Asma, for the insight into these things. And I keep saying it's all about strategy, isn't it? Yes, we've looked at the strategy that is supposed to be used here to help you go through your appeals successfully. The factors are very important. But if you need any further help, just call on BWF Solicitors on 0208 493 7340. They're available to help you do whatever it is that you have to do. And definitely, like our friend Osei mentioned earlier in the program where we had a client review, you would have very good feedback to give to BWF Solicitors, and also encourage people to use their services as well. BWF Solicitors, they work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. 0208 493 7340, or emergency situations 077 127 61884. Need I say more? Thank you very much, Lawyer Charles Asma, for your time. Thank you very much, BWF Solicitors, for the opportunity. And thank you very much, you out there, for staying with us for these wonderful 2 hours to be able to go through these all together. Once again, happy birthday to our dear Sheila Ankra, and to my producer, Professor Ade, and to Pamela Dodu for the aesthetics and all the other bits, and to Kofi Boateng. I understand you are Kojo Boateng, really, that's your name. Understand you have stayed with us all throughout from Ghana. Thank you very much. And to Comforter SBA as well, thank you for coordinating and doing that. Thanks you for your support all these years, Kojo, for thank you too for all the while you have been with us. Without you, we couldn't have done it. And we always want to do that together. So until the same time next week when we come your way with another edition of The Community. And the Lord, I want to say, enjoy summer, enjoy the sunshine, make the best of it. Be good. Good evening.